Everybody, welcome. Today we have a case that we're going to discuss that was filed in the U.S. District Court for the Southern District of Florida. And we have a plaintiff and all these different defendants. And this is a petition for review of denial of application for naturalization. I mean, most of the cases that we look at are mandamus cases where there's a delay and you're trying to get the case unstuck and keep it moving. But this is a review for the denial of application for naturalization. And a lot of times these types of cases don't succeed because there's a lot of discretion that the agencies have. But with mandamus, you're not going to get it approved, but you can't tell them to get it approved. But with that, you can get the case unstuck. But to win a denial for application for naturalization is very rare. It doesn't really happen. Okay, so here's a complaint. So here they're asking for a judicial review for the denial of naturalization application. And this plaintiff is a lawful permanent resident of the U.S. and resides in Florida. And they're saying the USCIS is an agency responsible for implementing the Immigration and Naturalization Act. And they list all these defendants. And then this jurisdiction and the venue is in the Southern District of Florida. And the reason it is in the Southern District of Florida is because the events giving rise to the claim occurred in Miami, Florida. And also this is where they denied the application for naturalization, and there was a naturalization appeal. So we'll discuss that in a second. So in 2015, plaintiff submitted the form N400. So N400 is the application for naturalization. She submitted to USCIS, and then she had an naturalization interview regarding her application for naturalization, and the application was denied. And the reason that they denied it is on the grounds that the plaintiff had improperly obtained her status as a legal permanent resident and thus was not eligible to apply for naturalization and become a citizen. Now, when that happens, she filed Form N336. So N336 is an administrative hearing. So it's to request a hearing on a decision on naturalization proceedings. And so this is an administrative appeal hearing. And the plaintiff presented additional evidence showing she had properly obtained her lawful permanent resident status as well as memorandum of law supporting the case. She appeared for an appeal hearing before the USCIS. Then they issued a final decision denying naturalization application. Plaintiff filed a petition for review of her naturalization denial at the U.S. District Court, Southern District of Florida. And then that petition was dismissed without prejudice for lack of proper service. So I guess the defendants were not properly served. So when you file a lawsuit, you got to serve your defendants. So I'm not sure if she had filed pro se by herself or not, but you got to know some of the things to do once you file a lawsuit. Okay, statement of facts. So here, she is a native and citizen of Colombia and was born there. She married somebody there, and they were married for 25 years, and the marriage produced 2 children. It is undisputed that this was a valid marriage. So in 2000, plaintiff entered the U.S. legally. It doesn't say how she entered. Was it on a B1, B2 visa? F1? We don't know. It doesn't say. And then the husband, then a legal permanent resident of the U.S., filed an I-130 for this spouse to petition his wife. And so that was in 2001. And then in 2002, he became a U.S. citizen. And then having received no response from USCIS, he again filed an I-130 petition for his wife, this time concurrently with I-485 adjustment of status application and the application for employment authorization. The plaintiff attended the interview in Denver, and her petition was approved when told she would be receiving her permanent residence card shortly. She received a stamp on her passport indicating that she was a legal permanent resident. She also received a Social Security card, and her petition for employment authorization was approved. Then in 2004, plaintiff and her husband were legally divorced in the U.S. Okay. Then the plaintiff then permanently moved to Miami, and she received a permanent residence card in Florida. However, the card had incorrect indication that she had been a permanent resident since 2005 rather than 2003, when her application was approved in Denver. In 2015, she submitted her N-400 application for naturalization. She attended a naturalization interview in Miami. That was denied by the field office, claiming that she did not qualify to be naturalized because her divorce in 2004 had made her ineligible to become a legal permanent resident based on marriage, and thus she's now unable to be naturalized. Then she filed an N-336, a request for hearing on her naturalization decision, and she attended that administrative hearing. There's an appeal, and they reaffirmed the plaintiff's denial. So what she's seeking is that she filed within the 6 years of her denial, and she has a right to obtain a judicial review. The evidence in the record establishes that at the time of her permanent resident petition, plaintiff was the wife of the American citizen and thus an immediate relative not subject to numerical limitations. So as an immediate relative, which is the defined as a spouse, there's no limit in terms of numbers of visas that could be given. The record further shows that a permanent residence petition was approved in 2003, long before her divorce became final in the U.S. Okay. Plaintiff would have received a permanent residence card in the correct date, which would have precluded defendant's mistaken basis for denial. And the USCIS policy manual specifies that administrative hearing should be conducted by an officer other than the officer who conducted the original examination or officer who denied the application. So what they're requesting is the court to assume jurisdiction over the matter, and then conduct a hearing on the naturalization application, grant the application for naturalization, administer the oath, and other relief as a court seems proper. Yeah, so these types of cases, I think, in my opinion, are pretty hard to win because there's a lot of the agency has a lot of say in what happens. But for mandamus, when things are stuck, that is different. But anyway, thank you very much for watching. If you like this, subscribe, comment, and when you subscribe, more people are able to find this channel. Thank you very much for your time. Bye-bye.